Good morning to everybody. All the young ladies of the college present here, dignitaries on the dais and in front of me, and everybody else, ladies and gentlemen. It is indeed a great pleasure and a great honor for me to be invited by the Rajasthan Education Trust and the Kanoria College for Women to deliver this lecture. I am indeed very grateful to both these institutions. Public interest litigation is a subject which I am sure most of you are familiar with. It started in India sometime in the 70s, late 70s, where it was spearheaded by the Supreme Court, when the Supreme Court said that anybody can approach the court in general public interest or in the interest of disadvantaged sections of society who cannot themselves approach the court, either for the interest of the general public or for the interest of some particular sections of people who are unable to approach the court by themselves. And therefore they said that in such causes, anybody who is genuinely interested in that public interest cause can come to court. He doesn't have to be an interested party, and therefore they said that there is no issue of locus standi as it is called, which means that your ability to pursue that petition will not be questioned so long as it is seen to be a matter of general public interest or in the interest of weak sections of society who cannot approach the court themselves. So, when this remedy was fashioned, the court used it in various public interest cases for the benefit of various disadvantaged sections of society, including prison inmates, for example, homeless people, migrant workers, Narega workers, and on many issues. The issues which the Supreme Court went into in PILs were issues relating to food, healthcare, education, shelter. Then in the course of public interest litigation, the Supreme Court also expanded the meaning given to some of our fundamental rights, particularly Article 21. Article 21, which is the right to life and liberty, was given an expanded meaning to mean everything that is necessary to lead a dignified life. And they said that, well, basic health care, basic education, basic shelter, all are essential for anyone to enjoy life or liberty, and therefore those were expanded. Article 19 rights, which are the various civic rights, freedom of speech, association, assembly, etc., they were also expanded and given an expanded meaning in various public interest cases to include the right to information. In fact, the right to information originally came from Supreme Court judgments starting in 1974 in the Raj Narayan versus Indira Gandhi or Indira Gandhi versus Raj Narayan case, where the court held that the citizens of this country, who are the masters of a democracy, have a right to be informed about everything that any public authority is doing in all its particulars, so that they can exercise their democratic right about expressing their views about what's going on and doing whatever they can to set things right. Similarly, more recently, the Supreme Court also held that the right under Article 19(1)(a) also includes the right to privacy. Of course, right to privacy has been held to be under Article 19 as well as Article 21, which is the right to life. In the course of public interest litigation, various fundamental rights have also been given an expanded and an expansive meaning by the Supreme Court. In that original ADR case, recently of course there has been another judgment in another case of ADR on electoral bonds, but the original ADR case was about the information about candidates contesting elections. So the Supreme Court held that it is the right of every citizen to be informed. In a democracy like ours, every citizen needs to be informed about the essential qualifications and disqualifications of any candidate who is contesting elections. For people to be able to express their right to vote in a meaningful manner, you need to know some essential information, and therefore they directed the Election Commission to take an affidavit from every candidate mentioning his assets and liabilities, his criminal antecedents, as well as his or her educational qualifications. So all that was done by way of public interest litigation by giving an expanded meaning to Article 19 rights. Essentially, the Supreme Court held that the right to speech is premised on, just as they said that the right to information is part of the right to speech. They said that you can't speak in a meaningful manner about what's going on in the country, what's going on in society, unless you are properly informed about what various public institutions and public authorities are doing. Same way they held that you can't express yourself meaningfully by way of giving your vote unless you are properly informed about the antecedents plus or minus of various candidates. And thereafter, as some of you may be aware, the then government brought a law, not government, the then parliament brought a law to overturn that judgment, to say that, well, this kind of information need not be given by any candidate through an affidavit. And that law was also challenged thereafter, and the Supreme Court struck down that law on the ground that, look, we have directed the disclosure of this information on the basis of fundamental rights of citizens. Therefore, if you are bringing a law to overturn this, that law is violative of those fundamental rights under Article 19, and therefore they struck it down. Recently, as some of you may also be aware, the Supreme Court delivered a very important judgment. A constitution bench of the Supreme Court delivered a very important judgment on the selection of election commissioners. You see, the Constitution said that the election commissioners shall be selected by the President. President meant the government. Until a law is framed by Parliament. Now, what was happening was that the government was selecting people who were partisan. Recently, this started happening. And just as the Supreme Court, in a case involving selection of judges, where the National Judicial Appointments Commission Act, which was a constitutional amendment, that constitutional amendment was challenged on the ground that it violates the independence of the judiciary, which is part of the basic structure of the Constitution. In that, essentially what had happened was that that Constitution amendment laid down that the judges will be selected by a committee consisting of 3 senior judges of the Supreme Court, the law minister, 2 other jurists chosen by the other members, and the secretariat will be in the law ministry. The court held that this gives ample scope for the government to interfere with the selection of judges, because earlier the Supreme Court had said that in order to preserve the independence of the judiciary, the selection of judges cannot be left to the government. You see, the origin of this case was that originally the law, the constitution said that judges will be selected by the president president meant government in consultation with the Chief Justice. So initially the view was that government could select, they only need to consult the Chief Justice. Later the Supreme Court in another judgment held that look, if you allow the government to select judges, that actually interferes with the independence of the judiciary, which is very, very important in our democracy, because the judiciary has been given a very important job, the higher judiciary, that is the High Court and the Supreme Court, which is to protect fundamental rights of citizens, which are essentially violated by various authorities and governments. It has also been given the job of protecting other institutions, other democratic institutions, and for ensuring that the executive and the legislature act within the bounds of their powers. So, in order for the judiciary to perform this function, it needs to be totally independent of the government. And one aspect of, though they have been given functional independence in the sense that government has no disciplinary power over judges and only judges can be removed by a process of impeachment, which is a very difficult process, yet they said that even appointments, if the appointments are controlled or interfered with by the government, that itself will interfere with the independence of the judiciary, and therefore they took over the appointment and selection of judges in their own hands by providing that judges will be selected by a collegium of senior judges of the Supreme Court. Thereafter, the only role of the government is that if they do not agree with a particular selection, they can send the name back once to the collegium of senior judges. And if the collegium reiterates those names unanimously, then those persons have to be appointed. It's another matter, unfortunately, that this present government has unfortunately not even been following that judgment. And we are seeing a very large number of cases where recommendations of judges made by the collegium are not acted upon by the government. They just sit on those recommendations for several months, sometimes even years altogether. And even occasionally when they return the recommendation by saying that we do not agree with it, and thereafter the collegium reiterates the same recommendations unanimously, even then the government has not been issuing the notification for the appointment of those judges. But in that case, in the judicial appointments case, the Supreme Court held that even interference by the government in the process of selection of judges will detract from independence of the judiciary, and therefore they said that violates the basic structure of the Constitution. Now here in the Election Commission case, a Constitution bench held that you can't leave the selection of election commissioners, who are very, very important in our electoral democracy to conduct free and fair elections, to the government. This cannot be controlled by the government, and therefore they said that till a law is made by Parliament, we are directing that the selection will be made by a committee consisting of the Prime Minister, Leader of Opposition, and the Chief Justice of India. So this was a recommendation made by Law Commission and various other commissions which had gone into the question. They were all saying that, well, the Constitution says election commissioners will be selected by the President till a law is made by Parliament. And everybody was expecting that a law will be made by Parliament, and that was the sum and substance of the debates in Parliament also when the Constitution was being framed. Essentially, people said, well, law will be made by Parliament to provide for an independent selection committee. But unfortunately, that law was never made. And finally, the Supreme Court Constitution bench held that, look, you have to select them in this manner. Prime Minister, Leader of Opposition, Chief Justice. Unfortunately, this present government has overturned that also by bringing in a law which replaces the Chief Justice with another minister. So now you have Prime Minister, one other minister nominated by the Prime Minister, and leader of opposition, which means essentially that the government controls the appointments again. This law, just as in the earlier case of disclosure of antecedents of candidates, where the government tried to overturn that judgment by bringing in a law, same way this law has also been challenged in the Supreme Court on the same ground, which means that the Supreme Court delivered that judgment about selection of election commissioners on the basis of preserving the independence of the Election Commission, which they have held is a part of the basic structure of our Constitution. Thank you. So, if you bring a law which again shifts the business of selecting election commissioners in the hands of the government, clearly this law also violates free and fair elections, therefore democracy, therefore the basic structure of the Constitution. But unfortunately, despite the fact that one post of election commissioner was falling vacant and fell vacant in February, and this challenge came before that selection had to be made, and a plea was made that please stay the operation of this law and ensure that the committee to select the election commissioners remains what the Supreme Court has said: Chief Justice, Prime Minister, leader of opposition. But unfortunately the Supreme Court did not stay that law. So PILs over the course of the last, it's now been 45 years since public interest litigation started, more than 45 years. Public interest litigation has been on all kinds of issues, including issues, a very large amount of public interest litigation is on issues of environment. Because the Supreme Court held that Article 21 rights also include the right to a fair environment for citizens. And therefore they said that, look, you can't indiscriminately do things which destroy the environment, destroy the forests of this country, etc. And therefore there has to be some check on the ability of the government to pursue policies and decisions which wreak havoc on the environment, on forests, etc. So there has been a large amount of litigation, public interest litigation, for example, on mining. Iron ore mining in Karnataka, iron ore mining in Odisha, iron ore mining in Goa, etc., where the court has stepped in to ensure that mining is regulated and is not done in a manner which just wreaks havoc on the environment there. Similarly, there have been recently a large number of cases on corruption, because the court has also held that having a corruption-free society or a society which has less corruption is also part of Article 21 rights. And therefore, they have... So it started in a way with that Vinit Narayan case involving the functioning of the Central Bureau of Investigation, where the court not only held that corruption or a corruption-free society is part of Article 21 rights, and therefore in order to enforce that right or that limb of Article 21, the court can interfere to ensure that anti-corruption agency like the CBI is able to function independently of the government, because very often the government or senior government functionaries are themselves involved in that corruption which the CBI is investigating. And therefore, if the government controls the CBI completely, they will not allow the CBI to investigate those cases which involve senior people of the government. And therefore the court said that, look, you need to bring about these institutional reforms within CBI to ensure that the CBI director enjoys a fixed tenure, to ensure that the CBI director is selected in a manner where the government doesn't totally control the CBI director, and about transfers, etc. within the CBI. Various directions were given. Similar thing the court did in the police reforms case of Prakash Singh, where the issue was that, look, the police is also not being able to do its duty, especially in the role of investigation of crime. It is not being able to do its duty even for law and order. The police has two kinds of functions, law and order and investigation of crime. It is not being able to do its duty properly because it is excessively controlled by the governments, and governments or senior government functionaries are often involved in either situations of law and order and certainly often in situations of crime. So therefore, they gave a series of directions. Of course, there is always a basis for these judgments. So the court analyzed a large number of committees which had gone into this question of police reforms and making the police independent of the government. Started with the Shah Commission after the emergency. And thereafter there were a series of commissions, the Dharamveera Commission and various other commissions which had given reports. And the court said that, look, so many commissions have gone into this matter for the last 30 years, and yet no reforms which have been recommended by these commissions and committees have been made, and therefore we are directing, in order to preserve law and order in this country, to ensure that the police does its job of investigating crimes, does its job of preserving law and order, and the rule of law. They gave a series of 6 directions about police reforms. They said that the police chief in every state has to have a fixed tenure, the police chief has to be selected in this manner. They said that there has to be a police establishment board which takes care of transfers and postings of police officers above a certain level, etc. All those directions were given. So, what I am pointing out is that apart from taking up several issues involving Article 21 rights and within the expanded meaning of Article 21, etc., the court in its public interest law jurisdiction has also started giving directions for institutional reforms of institutions which are critical for the functioning of our democracy, like Election Commission, police, CBI, civil services. So there have been a slew of decisions on institutional reforms also, on sexual harassment of women, that famous Vishaka case, where the court said that, look, there are international conventions which India has signed, which can be read into our domestic law unless there is a domestic law to the contrary. And therefore they said that every institution needs to set up a sexual harassment committee, which should have a certain character, which should be able to independently investigate complaints of sexual harassment against women. So, this has been the sort of growing range of issues which have been taken up by the Supreme Court primarily in public interest litigation. Of course, the high courts are also fully empowered. Article 22-26 empower the high courts equally to take up and deal with public interest litigation in the same manner in which the Supreme Court can do. Now there are some specific issues which have come to be raised from time to time about public interest litigation. One of them is that, of course, there has been some pushback from the government on public interest litigation because the government says that there is judicial overreach by the judiciary, they are interfering with executive functions, they are interfering with governmental functions, the court is spending too much time on public interest litigation. All these kind of criticisms have been made, and mostly these criticisms come from the government. From various governments which are in power. Now it is true that, and there is also now, the judiciary is also saying sometimes that there is misuse of public interest litigation, that there are publicity seeking public interest litigation being filed. They also say that there are malicious public interest litigation being filed by interested parties and so on. And there are issues of constructive or res judicata or constructive res judicata which have been raised in public interest cases. Now these are all related issues. So first question is, what do you mean by so there are in fact some publicity seeking PILs which are filed. These are primarily half-baked PILs which are being filed today because public interest litigation gets a lot of publicity, and therefore there are people who somehow, whenever they feel that there is some issue which can be taken up by way of public interest litigation without doing the necessary research, without preparing a proper petition, just in order to be first off the block, so to say, they quickly file a PIL, and it is often done for publicity. It is often done for publicity. Now, and sometimes, now this is now another phenomenon which we are seeing, sometimes public interest litigation is deliberately filed in a half-baked manner in order to ensure a dismissal of that PIL so that later proper, genuine PILs on the same subject are barred. Because then the court says, because the Supreme Court had held in one case that even in public interest litigation there can be not only res judicata, but there can even be constructive res judicata. There was a case of forward construction where, unfortunately, in my view, the Supreme Court gave a totally wrong judgment in that forward construction, where they said that in public interest litigation there can be res judicata and even constructive res judicata, which meant res judicata is that, look, this issue has already been decided by the court, so we can't entertain your petition. So if a person files a bogus PIL, as some people are now doing occasionally, they did it in the Rafael matter, they did it in this Adani Hindenburg matter also. These are called ambush petitions. There is a term which has been given to them. They are called ambush petitions, which means the intent of these petitions is to ambush future genuine public interest litigation on the same issue. Now, strictly speaking, if person A files a petition even on some subject and it is decided against that person, the petition is dismissed, then res judicata does not bar another person from coming to court raising the same issue. But the court, unfortunately, in that forward construction case held that no, res judicata will also apply to public interest litigation, meaning that public interest litigation will be deemed to be filed by everybody, and therefore anybody coming in future on the same issue will also be barred by an earlier judgment on that issue. Even if the issues raised in that petition have not been decided or not even been considered, or even if those issues which have been raised in the second petition were not raised in the first petition. They said even constructive res judicata will apply, because if there is a ground which you could have taken in the first petition, or somebody could have taken in the first petition, but was not taken and therefore not decided, even then a future petitioner will be barred from raising that issue in a subsequent petition, where he is raising an issue and taking a ground which was not even taken in the first petition and therefore not decided. But fortunately, there has been a recent judgment of the Supreme Court in a case called Confederation of Officers Associations, which involved the privatization of a company called Hindustan Zinc, which was privatized to a company called Sterlite or Vedant. In that, the Supreme Court has held that, look, we need to be wary when dealing with public interest litigation. We need to be wary of this phenomenon of ambush petitions. And therefore, unless an issue has been properly considered and decided in an earlier petition, a subsequent petition raising that issue will not be barred on the ground of res judicata or constructive res judicata. So this is a very, very important principle. But on that issue of half-baked, publicity-oriented petitions which are also being filed today, you see, when we think of, because many of you are going to be lawyers soon, and many of you will perhaps want to file some public interest petitions also. So when you ask this question as to what do I do when I see some issue which is of public interest, which I feel can be taken to court by way of a public interest petition, what should I do? What is the job of a lawyer who is thinking of filing a public interest petition? So the first thing is that you think of what is the prayer that you want to seek. That means, what is the relief that you want to seek from the court? What is the direction that you want the court to issue? For example, you see a problem of corruption, and you say, well, there's a lot of corruption in the country and I want to file a PIL on corruption. All right. Now, suppose you go to court saying that there is a lot of corruption in the country, so the court should issue directions to stop corruption. The court will say that, look, what direction can we issue? How can we stop corruption? Yes, there is corruption in the country, but what do you want us to do? How can we do something which will stop corruption? That's the job of the government. What will the court do in this matter? So the first thing for you to think of and focus on is the prayer that you want to seek or the direction that you want the court to give. And this kind of direction that stop corruption is meaningless. Suppose the court issues a direction to all the government, stop corruption, that's not going to make any difference. So unless the court issues a direction which has some meaning, if the court says, look, this is the anti-corruption agency, the CBI, one of the reasons for the ongoing corruption is that the CBI's hands are tied or the CBI doesn't have enough powers, and therefore we direct that the CBI's hands should be untied, that the CBI should be given these powers, etc. That makes some sense. So you have to focus first on the prayer or the direction that you want the court to issue. Then you have to next focus on what is the basis for seeking this prayer. Because ultimately the court will say, look, you have to show what is your right or what is the right of any citizen to seek such a prayer. And what is the ground on which the court can interfere in this matter or court can give such a direction? Therefore, you have to show which is your fundamental right or constitutional provision which is being violated, as a result of which you are seeking this prayer. So, for example, in the case of selection of judges, the court said that, look, independence of the judiciary, which is part of the basic structure of the constitution. In the case of election commissioners, they said free and fair elections, which is part of democracy, which is part of the basic structure of the constitution. In the case of the information to be given by candidates, etc., the court said this involves your Article 19 rights, the right to be informed about candidates, just as the right to information, they said, is part of Article 19 1A rights. The right to speech includes the right to information. So ultimately you have to show what is the right which is being violated for which you are going to court. And lastly, and this is very important, see, for example, recently we filed a petition challenging these vaccine mandates which were being issued for COVID, that anybody who doesn't take the COVID vaccine will not be allowed to travel, will not be given as rations and so on. So various governments were issuing these various mandates, virtually forcing people to take the COVID vaccine. Now, when you go to court on such a matter, or on any matter for that matter, you have to get the best possible information and understanding on that subject. Because otherwise, what will happen is you will file a half-baked petition which will get dismissed because you were not able to present to the court the best information and understanding that was available on that subject. And therefore that is going to adversely affect future PILs which can be filed by people who have a much better understanding of that subject. And therefore it is your duty as a public interest lawyer to find out what is the state, what is the best possible information and understanding. Of course, it is not always possible to get the best, but you have to make that effort to find out who are the experts who have worked on this issue, who are the people who have written about this issue. So today in the age of internet, it is relatively easy to find out. Earlier it was not so easy to find out. And therefore you have to make that effort to find out who are the best people who have written about this issue. Of course, there is a word of caution here. Those people whom we consider experts often have vested interests. And you have to be very, very wary of that. Because a lot of so-called experts in the country on different subjects are funded by vested interests, are funded by people who have a financial stake in that issue. A lot of people who masquerade as experts, and we saw that very, very clearly in the COVID vaccine case. A lot of the so-called expert advice that we were being given by various authorities, by various doctors, by various people was eventually coming from these pharmaceutical companies which were manufacturing these vaccines. So they ultimately were emanating from commercial vested interests who were, quote unquote, polluting the expert advice on this issue. Therefore, in fact, one very interesting study, or rather two very interesting studies were done. One relating to genetically modified organisms, one relating to soft drinks. So there were a large number of papers published. We have filed PILs on both these subjects. On genetically modified organisms, if you separate the studies which are directly or indirectly funded by the GM companies, Monsanto, Bayer, and so on, versus those studies and those papers which come from totally independent scientists, you find that there is a difference of night and day. Virtually all the papers which are directly or indirectly funded by the industry will say that genetically modified organisms and genetically modified foods are totally safe. And virtually all the papers coming from independent scientists who are not funded in any way directly or indirectly will say exactly the opposite. That GM foods have all kinds of negative health consequences and environmental consequences. Same thing about soft drinks. You separate the studies and the papers on the basis of those which are funded directly or indirectly by the soft drink industry versus those which are not funded, and you will find a difference of night and day. And therefore, you have to be careful of who is seen as an expert, and therefore go to those studies and those papers which are not by people who have any kind of direct or indirect financial interest in that issue. Only then will you get the proper expert advice or information. Now, future of PILs. So, see, public interest litigation normally ruffles the feathers of the government, and public interest and effective judgments in public interest cases, whether it's on electoral bonds or any other thing, eventually ruffles the feathers of the then ruling governments. And therefore, there is a very, very serious pushback against public interest litigation and courts giving judgments in PILs by the ruling governments. And therefore, to a very large extent, the future of PILs in this country will depend on the future of the independence of our judiciary. Over the last several years, we have been seeing, especially in the tenure of this present government, we have been seeing very serious attacks on the independence of the judiciary. These attacks are coming by way of offering post-retirement jobs to judges who do the bidding of the government when they are in office, and they give judgments in favor of the government. As Arun Jaitley said in Parliament once, post-retirement jobs influence pre-retirement judgments. And we have seen any number of people. There was the case of Chief Justice Gogoi being given Rajya Sabha membership after the Rafale judgment, after the Ayodhya judgment. There is the case of this Justice Arun Mishra giving any number of judgments in favor of the government and then being made chairman of the National Human Rights Commission, where he presides and holds seminars on how human rights organizations are defeating human rights. I mean, this is the kind of thing that this gentleman who's been made chairman of the National Human Rights Commission is doing. There is the case of, now recently the case of Justice Khanvilkar, who has given any number of absolutely horrendous judgments on civil liberties, restricting the scope of civil liberties, expanding the powers of the enforcement directorate and so on, who gave a judgment saying that Teesta Setalwar should be prosecuted for raising the case of Gujarat riots, who gave a judgment saying that Himanshu Kumar should be prosecuted for raising the case of tribals who had been killed in police encounters in Chhattisgarh, etc. He has recently been appointed Lokpal. So, this is one problem. Second, of course, is that when there is a very strong fascist government, we find that except some very strong, robust judges, a lot of judges are just too weak and unable to stand up to a fascist government like the present one. The third problem is that this government has adopted this policy of just not appointing judges who are seen to be independent. So they didn't allow the appointment of Justice Muralidhar, they didn't allow the appointment of Justice Akhil Qureshi. They have been sitting on the nominations of virtually every Muslim judge who is recommended by the by the Collegium of the Supreme Court. They have been sitting on actually dozens of people who have been recommended by the Collegium. Ultimately what the Collegium does is, unfortunately, you see, I have been telling them that look, this is contempt of court. You need to haul up the law secretary or the law minister for this contempt of court. If they are not following the judgment of the court, you need to haul them up. But unfortunately, they do not have that strength to haul up the law minister. Therefore, what they are doing is, they are then entering into a compromise. All right, you please appoint 2 of our judges and we'll appoint 2 of your judges. 2 of the judges recommended by the government and 2 judges recommended by us. This kind of compromise is taking place. And of course, in that process, it is not that no independent judges are getting appointed to the Supreme Court or the High Court. A few do get appointed. Out of the 2 recommended by the Collegium who get appointed, one may be independent, one may not be so independent also, because there is also a lot of nepotism in selections by the Collegium. So therefore, gradually over the years we have seen that the percentage of independent judges coming to the Supreme Court or the High Court has been reducing. And of course the most dangerous thing that this government has been doing is to prepare dossiers on every judge, asking IB, CBI, ED, income tax, all to prepare dossiers on judges, and if they find some weakness of that judge or any close relative of his, then that they use that to influence that judge. As a result of which, over the last 7, 8 years, we have seen the Supreme Court and the judiciary in general, high courts also, they have gradually and progressively lost their independence. And therefore, the future of public interest litigation will depend largely on whether the courts are able to rise up and regain their independence or not. Because if they are not able to do so, then unfortunately I see a bleak future for public interest litigation in this country. And of course I would like to see, there are many issues which the courts need to take up by way of public interest litigation. Today, despite the Supreme Court's judgment on police reforms have not been implemented. Despite the Supreme Court's judgment on even CBI's independence, we are seeing that the CBI is functioning like a caged parrot. The Supreme Court has also said so. So all institutions, Election Commission, despite the Supreme Court's judgment, the Election Commission is still functioning as a caged parrot. The Comptroller and Auditor General, which used to be an independent institution, its independence has been very, very drastically reduced in recent years, with the result that the number of audits that the CAG does of central government has come down to by more than 75%. It has been reduced by more than 75%. In the Rafale defense deal, for the first time in any defense deal, the CAG omitted the pricing details from its audit. And this was done at the behest of the government, because the government filed a note before the Supreme Court in the Rafale case saying that the CAG audit report has come, which it had not come by that time. And the pricing details have been omitted. How did the government note that the pricing details would be omitted? They had never been omitted in any defense audit, but in this case they were omitted, obviously at the behest of the government. So what we are seeing is a progressive destruction of the independence of all kinds of institutions, including educational institutions like universities, etc. In universities also we are seeing the same thing, that people who are recommended by the RSS are being appointed vice chancellors. Some of them are not even qualified for the job, even according to the paper qualifications of the UGC. But all that is happening. Then there are serious issues of institutional reforms of our democracy itself. Today, democracy or elections have largely become a game of money and propaganda. And money and propaganda have come into the hands of only the ruling party. Today, the BJP has more than 60% of all the funds of all political parties put together. That means the BJP has twice as much funds as all the other political parties put together. They have control over all instruments of publicity. Of course, they use the government funds as well as government servants for publicity, all these selfie points, etc. They also use government funds to influence all these other media organizations by giving them government advertisements. Thousands of crores by way of government advertisements are being given to influence the media. So therefore, these are very, very serious issues of our democracy. Today there is a limit on the spending of election of candidates, but there is no limit on the spending of political parties. In the last election, it is estimated that the BJP alone spent more than 30,000 crores. The limit for one candidate, that means for 500 candidates in Lok Sabha, put together is less than 500 crores. But if the party spends 30,000 crores, what is the meaning of this limit of 90 lakhs or 75 lakhs on individual candidates? So therefore, there are a large number of issues affecting our democracy, affecting our democratic institutions, etc., which can be and should be taken up by the courts as by way of public interest litigation. But whether they will be taken up or not depends critically on to what extent the courts are able to resurrect their independence, which has been dwindling in recent times. And therefore, lastly, coming to the role of lawyers. You see, lawyers need to play an important role in society. In the independence movement, it was mostly lawyers who were involved. And that's one of the reasons for that is that lawyers understand the law, understand how society is constructed, how society functions, what are the various institutions which make civil society or orderly relations in society. And that is also one of the reasons why lawyers have been at the forefront of social reforms, political reforms, etc. But in the recent past, what we are seeing is, there was a time during the emergency when the bar stood up as one in the Supreme Court, in Bombay and so on against the emergency. But today, despite the virtual collapse of our democracy in this country, virtual collapse of institutions in this country, we are not seeing lawyers rise to that occasion. And therefore, we need more public-spirited lawyers in this country. Lawyers who keep their eyes and ears open and see what is happening in society, who engage with major public issues in our society, in our country, and occasionally go to court when there is a serious issue which can be taken to court by way of public interest litigation. Of course, public interest litigation should be done pro bono, that's my view. And the reason is that the lawyers should not have a financial stake in that matter if they are doing it in public interest. So it should be done pro bono. But just one word before I end, though it's a somewhat negative note for ending. You see, there is a progressive collapse of our judiciary in this country. It's not merely because of the independence of the judiciary being collapsing. It's also because the judiciary is virtually dysfunctional. Firstly, ordinary people cannot approach the courts to get justice. That's why vast majority of the people languishing in jails are not even, they are under trials or under investigation. They are not convicts. And they are there because they can't have the wherewithal, they can't engage a lawyer. If they are confronted with a false charge sheet by the police or a false accusation by the police, all that they can do is to stand like this before the judge and say, Hujur, humne kuch nahi kiya. That's all that they can do. So therefore, we have to have a system where ordinary people can access the courts without the help of lawyers. And the Gram Nyayalayas were supposed to be those courts. The Gram Nyayalaya Act came many years ago, but unfortunately it has not yet been implemented, hardly been implemented, and not even 5%. Not even 5% implementation of Gram Nyayalaya. Then we need more courts. Law commissions have been crying hoarse that we need more courts in this country, more infrastructure. The government is not interested in providing that. And even unfortunately the judiciary is also not pushing the government to provide that. Then we need a better system of selecting judges. Even this present system of collegium is not a very satisfactory system. It's better than the government selecting the judges because it provides for slightly more independent judges. But it is not the ideal system. Ideally, we need to have a full-time judicial appointments commission and also a judicial accountability commission instead of this process of impeachment, etc. So there are many judicial reforms that need to be done in order to save our judicial system from the virtual collapse state in which it finds itself. And therefore, now how and why will that happen? How will judicial reforms take place? Judicial reforms, unfortunately, neither the government is interested nor even the sitting judiciary is interested. Unfortunately, I have seen that. We have filed case on institutional reforms, including judicial reforms. But the response of the judiciary is the least in the case of judicial reforms. It is there in the case of other reforms of other institutions, but on judicial reforms there is virtually no response from the judiciary. Therefore, the only way in which these reforms will happen is if there is a robust people's movement on judicial reforms. We need to have a movement like there was on Lokpal or the movement like we had on RTI, etc. Only that will bring about the judicial, put enough pressure on the government and on the system in order to bring about these reforms. In the absence of these reforms, you see, as lawyers, you can practice in court, you can even make money, but you will not have much satisfaction that you have been able to deliver justice to people. Unfortunately, there is very little justice being delivered to people in our present system. The other caution that I wanted to sound, and I need to sound that caution because I believe that's what is the shape of things to come. I have been studying the developments in artificial intelligence now very closely for the last couple of years. And I have no doubt at all that in the next 10 years we will have what is called artificial superintelligence, which is an autonomous artificial intelligence which is superior to humans in every possible way. The only difference will be that it will not have emotions like us. I have written an article about that. If some of you want to read about it, you can read it in the Wire. But all jobs like those of architects, doctors, lawyers, judges, engineers will all go. Because artificial intelligence will be able, even judges, artificial intelligence will form far better, far fairer judges than humans have ever done. And therefore, I feel that this profession is about to get over. And it's unfortunate, but this is what is the shape of things to come, and the shape of things to come in not too distant a future. The only jobs that will survive, in my view, are those jobs which deal with human emotions, that is, writing books, creative books, making movies, or anything else to do with music and so on, which deal with human emotions. Because that's one aspect which AI will not take over, but otherwise I feel, however, that's something that is still some way off. If till that time we are able to reform this system, if we are able to put enough pressure to reform the system, we will still see us getting some job satisfaction by way of getting justice for our clients. If we are able to resurrect the independence of the judiciary, we will still see some important orders on institutional reforms and public interest litigation in this country. Thank you very much.